The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
May be seated. Mr. Messina?
Good morning.
Good morning.
May it please the court, Paul Mazzina for the appellant, Sammy Louis Stokes. Your Honors, when we briefed and argued Mr. Stokes' constitutional claim more than a year ago, the state not only didn't cite Section 2254E2, it also affirmatively invited this court to rule on the merits of the claim based on the evidentiary record that was developed in the district court. Only after the state was unhappy with this court's ruling did it then reverse course and try to retroactively nullify that ruling by raising a 2254E2 objection to the same evidence that the state had previously urged the court to consider. The state admits in its supplemental brief that it was aware that this objection was available to it all along, and it simply chose not to raise it. That is not just forfeiture, that is deliberate, intentional waiver of the argument, and it's exactly the kind of sandbagging that the Supreme Court was concerned about in Shin versus Ramirez. We're asking the court to hold that the E2 objection was waived and reinstate the original panel decision. Now, subject to the court's questions, I'd like to do three things this morning. First, I'll explain how the state waived the argument in this court. Second, I'll explain how the state also waived the argument in the district court. And third, I'll address the state's request for this court to excuse or overlook the waiver.
Counsel, could I, in whatever order you choose to do it, I'd like you to at least respond to this question, which is this statutory requirement that we're looking at after the Shin decision something that affects our power to consider evidence that can be waived?
Sure, Your Honor. So let me take that right off the bat. First of all, the state hasn't argued that E2 is a jurisdictional limitation. Obviously, the court has to address its own jurisdiction regardless. But I think it's worth noting the state doesn't believe it's jurisdictional. And I think it's clearly not. The Supreme Court, in a whole series of decisions in recent years, has tried to really bring some discipline to what provisions are jurisdictional and has said that Congress has to speak in really clear jurisdictional language. And the court has noted mandatory provisions, even emphatically worded mandatory provisions, are presumed to be claim processing rules that are subject to forfeiture and waiver. And I think the court's decision in Day versus McDonough from 2006 is pretty helpful with this. The court there was addressing EDPA's statute of limitations, but its reasoning, it said, applied generally to EDPA's threshold limitations. And the court said these are not jurisdictional limitations, they're claim processing rules. If the state inadvertently forfeits them, so in Day, for example, the state, I think, had miscalculated the limitations period, the court has discretion then to reach the issue, although it's not required to. But if the state deliberately withholds the argument, then the court actually has no discretion. And in Wood versus Milliard, the Supreme Court reversed the 10th Circuit, said it had abused its discretion by reaching an argument under EDPA that the state had deliberately withheld.
Those are EDPA cases.
Those are EDPA cases, correct. So just to come back, Your Honors, to the proceedings in this court. So I think everyone agrees the state didn't raise E2 in this court, but the state did more than just not raise it. It affirmatively asked this court to rule based on the evidentiary record that was developed in district court. And I'd point you to two places just as examples. Excuse me. Page 71 of the state's brief, they said that if the default of the claim was overcome under Martinez, then, quote, the next step would be determining whether Stokes proved his case under Strickland. And the state argued that the court should hold that he failed to prove his claim based on the evidence from the district court hearing.
But let's talk about that. So let's assume, we're in a different context. You're in a products liability case, and a defendant moves to exclude an expert. Trial court says no, the expert's qualified, he gets to testify. The defense lawyer, cross-examines the expert effectively and gets either a directed verdict or a jury verdict. The plaintiff appeals the verdict, saying the evidence is sufficient to either warrant a different result or go to trial. I mean, isn't the defendant entitled to, at least in responding to those allegations, use the information that was elicited over its objection to the evidence coming in the first place?
Your Honor, the defendant can certainly argue in the alternative. It can say this was improperly admitted, but even if it was properly admitted, we should win anyway. But what the defendant can't do is embrace that evidence, refrain from making any objection to it, and wait to see how the case comes out, basically holding this objection sort of up its sleeve in case it gets a merits ruling it doesn't like.
So the winning party, your position is, has to raise arguments, even though it prevailed, or those are waived?
As to evidentiary objections, Your Honor, yes, absolutely. And let me address that, because I think this is the state's main argument against finding waiver in this court, is they say this was just an alternative ground for affirmance, and as appellee, we weren't required to raise it. And they cite for that an out-of-circuit case, the Federal Circuit decision in a case called Independence Park Apartments. There are two reasons that I think are very clear why that rule doesn't apply here. First, it's a rule that applies only when the appellant is seeking remand. And that makes sense, right? If you think about it, if the appellant is looking for a remand, the appellee can sometimes hang on to certain arguments that would be relevant on remand. And that's what happened at Independence Park Apartments. So that was a regulatory takings case. The claims court had held that there was no taking as a matter of law. The plaintiffs appealed that, and they were looking for a remand on damages. And the Federal Circuit agreed, said there was a taking, remanded for damages. On remand, the government was entitled to raise damages arguments that it hadn't raised in the Court of Appeals, because those arguments were properly reserved for the remand. But obviously here, we were not seeking remand. We were asking this court to rule as a matter of law that Mr. Stokes prevailed on his claim. So if the state had any objection to that disposition, it had an obligation to raise those arguments at the time.
Counsel, I understand what you're saying, I think, in distinguishing that case, but I mean, our circuit has addressed this issue very directly and said that, I'm quoting, even appellees waive arguments by failing to brief them. I mean, we've considered this question. We've come to a reasoned conclusion, which is that the obligation of appellants to raise their arguments or waive them comes from Rule 28A. Appellees, who are governed by Rule 29, are told that they too have to comply with Rule 28A. And so we held in Hillman, the waiver rule applies equally to both. I don't really understand how this is an open question in our circuit. It seems like an interesting question, a question on which circuits have taken somewhat different approaches, but we've addressed it.
That's absolutely right, Your Honor, and I obviously should have started there. This court has held, both in Hillman and in subsequent cases, appellees waive arguments that they don't brief. That's the law in this circuit. I did want to just respond to Judge Quattlebaum and explain why even this out-of-circuit case law doesn't support the state here. And just to wrap up that point, if you look at the cases that are cited in Independence Park Apartments, one of those cases makes exactly the point I'm making here. It's Judge Posner's decision in a case called Shearing Corporation versus Illinois Antibiotics. And there, the issue was very similar. The case had gone up to the Court of Appeals on a question about the meaning of an injunction. The parties litigated it. And then the party that lost tried to go back and challenge the evidentiary record that the court was relying on at the time. And Judge Posner said, whatever arguments appellees can hold on to in some circumstances, you clearly can't do that. That would be an unworkable system if a party could essentially gamble in the hopes of getting a favorable merits ruling and then after the fact try to challenge the evidence.
Following up on Judge Harris's discussion and question about the Hillman case, certainly it talks about that both, under the rules, both parties can waive arguments. But doesn't there it ultimately conclude that the court, certainly can address the issue that was not raised? And it cites to the, admittedly out of circuit Hernandez case, which, really talks about the burdens really on the appellant, the losing party. How does that factor into this?
Your Honor, if an argument is forfeited through inadvertence, the court always has discretion in the interest of justice to reach the forfeited argument.
Right.
We think it would obviously not be in the interest of justice for the court to do that here, where the court has already held that Mr. Stokes was sentenced to death without a fair and constitutionally compliant sentencing hearing. But even apart from that, where the state has deliberately withheld the argument, that discretion doesn't even exist. It would be an abuse of discretion to reach that deliberately withheld argument under Wood versus Milliard.
Do you make any, do we take any, does the fact that you raised this issue before the Supreme Court and it vacated our opinion and, remanded for us to consider the case in light of Shin, does that have any weight at all?
No, Your Honor, it has no weight. The Supreme Court has been very clear that its normal practice in GVRs is to leave preservation issues to be addressed by the Court of Appeals on remand. The justices themselves have noted that on numerous occasions. We cite some of those in footnote 1 of our supplemental brief. This court also has a long and consistent practice, which is consistent with other courts of appeals, of addressing preservation issues on remand following a GVR. Of course, we had to put it in our brief in opposition in the Supreme Court. If we hadn't done that, then presumably we'd be here hearing that we had abandoned the argument by not raising it there. But we knew in doing that the likelihood was the court would leave it to be addressed on remand. So I do think it's worth pointing out that there's no question the state was on notice of the availability of this argument. 8 months before the state filed its brief in this case, this court decided a case called Moore versus Sterling with the same defendants represented by the same counsel. And in that case, this court noted the availability of the E2 argument, noted that it was an open question in this circuit and that it hadn't been raised by the parties in that case. So the state was certainly on notice and aware of this argument, and they don't say otherwise in their supplemental brief. They deliberately chose not to raise it, presumably because they hoped to get a favorable merits ruling that would be more helpful precedent going forward.
Counsel, can I ask one question? I want to make sure I at least get this out before your time's up. And it's your alternative argument that even if we consider the application of E2 here, that you should still prevail under the conflict of interest issue and the Aiken issue. And I'm not asking about the conflict of interest issue, I'm asking about the Aiken issue. I think from my understanding of the record, there is state court, the testimony itself of Aiken is available from the state court record. So you could look at that testimony and make some assessment of that. But any discussion of the rationale, the strategy, why the lawyers did that would only be available from the evidentiary record developed in federal court. Am I right in that?
That's right, Your Honor. The Aiken claim wasn't raised in the PCR proceedings, so trial counsel, I don't believe, gave any testimony specifically about Aiken. So the court would just be looking at the trial court record, which, as the court pointed out in its decision, reflected almost no mitigating presentation at all. The court noted the problems with Aiken's testimony, that he wasn't familiar with important parts of the record, that his examination took up only about 4 pages of transcript, and his cross-examination was about 5 or 6 times as long, and that he had this sort of what the state called an Alice in Wonderland theory of prison adaptability, where he didn't even testify that Mr. Stokes would be able to refrain from violence in prison. And notably, didn't even call attention to the fact that Mr. Stokes, after having a number of violations in his first 5 years in prison, had no violations in his second 5 years, given that this was the entire purpose of Aiken's testimony, was to say he can adapt to prison. It's just bizarre that he didn't call attention to that. And all of that you can find from the state court record. And just briefly, before I sit down, I want to address the proceedings in the district court and just give you some citations that you can look at if you're interested in that. Obviously, the waiver in this court is dispositive, but I don't want the court to have the misleading impression that this was preserved in the district court. So first, in response to the habeas petition, the state specifically suggested the court might want to hear testimony from trial counsel Sims and Johnson. That's docket 89 at 17. In the state's motion for summary judgment, they noted that if the claim was not procedurally barred, it would, quote, require a full airing of the claim with appropriate fact-finding before the merits are decided. That's docket 161 at 92. The state's pre-hearing brief, docket 159, is the only place where they brought up E2, but even there, they just used it to argue for a sort of bifurcated procedure in the hearing. They didn't use it as a basis to oppose the hearing. And then at the hearing, I'd point you to Appendix 2862 and 3560. The magistrate said she would address the state's objections as evidence came in. At the conclusion of the hearing, the state said, quote, if it's a matter that's properly received in evidence, then it's before the court properly. And that was the last we heard of E2. I'll save the rest of my time for rebuttal. Thank you.
Thank you, Mr. Messina. Ms. Brown?
Thank you, Your Honor. May it please the court. One thing in listening to the back and forth this morning, I want to clear up because it puts everything in context and perspective. For the argument itself, there is a difference between expanding the record for determining whether somebody can excuse a default and expanding the record for the underlying claim of ineffective assistance of trial counsel. That has been meshed in the presentation this morning. When it's properly separated, you can see exactly what the state did, what the warden did in district court to preserve the integrity of the state court record. Now, you just heard a few of the cites and some of the arguments that we made. But again, keeping that division in line, you have to see what we did before. We objected to the hearing, absolutely. We said 2254E2 prevents expansion of the state court record for determination of any kind of underlying issue. That's exactly what we argued. We also moved to strike affidavits. We were protective of that state court order, and that's on Joint Appendix 2850. So we're already in a better position than the state in Shin. But there's more. And this was what was omitted in just that last litany of cases and what we said in the district court. On the first day of the evidentiary hearing, before anybody testified, very first day, January 8, 2018, and this is at Joint Appendix Site 2862, we asked for our objection to the entire proceedings under 2254E2 to expand any part of the record for a claim to be a continuing objection. A continuing objection, and the magistrate granted that.
Counsel, if you assume you preserved it at the district court level, how do you get past our Hillman decision?
Again, a distinction. We've talked a lot about civil cases. AEDPA is not a normal civil case. AEDPA restrains federal courts from the normal rules and gives a deference to the separate sovereign, the state, that's not seen in other civil cases. Going back to the Hillman case out of this...
It's your understanding that waiver rules just don't apply to the state in this context?
They cannot, Your Honor, because it's AEDPA. And I think going back to Hillman...
How do you address, your colleague cited the pair of Supreme Court cases saying that these AEDPA preconditions are not jurisdictional and they can be waived by the state?
Well, I will say that it's not addressed specifically in the case law as of to date.
In what sense is it not addressed specifically in the case law? I don't
We
understand.
do not have a case
You think that this
says-
provision might be different? All of the other AEDPA provisions are non-jurisdictional, but this one is jurisdictional? Is that?
Actually, Your Honor, 2254D1 has been deemed jurisdictional.
Is there a reason why the Supreme Court would have put that footnote in Shin about the forfeiture question? If this were a jurisdictional question, wouldn't that footnote simply have said this is jurisdictional, it can't be waived?
Well, there's no explanation of why they did. They forgave it. Why did they forgive it? I would
But
suggest
there's,
one reason.
your position is that there is nothing to forgive. This is not waivable, it's jurisdictional. That would render that footnote, more than superfluous. It would render that footnote incorrect.
I don't believe it would be incorrect. It's just the basis. You can forgive that, any kind of procedural rule or forfeiture, because it is a limitation on the authority of the federal courts.
That puts a different meaning on forgiveness, doesn't it? If it's impossible to sin, there's no need for forgiveness. If it's jurisdictional, you don't have to forgive that.
Well, if we turn to just looking at the rest of the cases in the Shin case, we also have the Holland case from, I think it's 2004, and there they rejected a procedural argument. In that case, I think it's very interesting because, again, EDPA coming up, nothing was decided against the state until the Court of Appeals. At the Court of Appeals, Tennessee did not do a petition for rehearing or otherwise raise that. However, the Supreme Court, much like the footnote that Judge Harris and you are concentrating on, said we forgive, or we don't find a procedural bar, or we don't find an issue there. That doesn't change the text of EDPA. And to go back to the suggestion that maybe it could be waived, this isn't a defense. This is a limitation on federal courts' ability to act.
Just so I understand your position, so you are not arguing that you didn't, you are not arguing that this was preserved before us. You are saying it didn't have to be preserved because it's jurisdictional.
Yes, ma'am. And
Okay.
to go back before Hillman actually...
You are not arguing that it wasn't, if this were non-jurisdictional, you are conceding that it was waived in front of us, but it is not a problem that it was waived because this is jurisdictional. That's your position?
Not exactly. In Hillman, this court cited to Hernandez versus Starbuck. Hernandez versus Starbuck is an EDPA case. And the Eighth Circuit there drew that distinction that an appellee in an EDPA case only wants to preserve the judgment. And in that case, there are no specific rules that you have to have all of your alternative arguments to raise. And let's go back here on what was appealed. What was appealed was the district court ruling. The district court never accepted evidence in support of the underlying claim for a merits ruling. The first time that 2254E2 was actually offended was the merits determination that this court did in the opinion. That's very important because they also ask us, well, why didn't you raise it to the magistrate? Why didn't you raise it better to the district court? First of all, we preserved our objection, and no court prior to this one ever expanded the records for purposes of a merits ruling. That's what makes this a little bit different. This isn't giving up something we lost in the district court. We were the prevailing party. And again, this flows right back into the Hernandez case, that because you're the prevailing party, all you want to do is keep the status quo. That is almost a direct quote from Hernandez. It's a very interesting read, and other circuits have said similar to this. Now, I will agree we have Hillman, but Hillman's not EDPA. And there's a deference built in to the EDPA structure that does not exist in other cases. Now,
Are you conceding that it was your deliberate strategy to hold back this?
no, sir.
Okay, well, it sounded a whole lot like the last thing you said was.
We have no deliberate strategy to hold back. We never lost.
No, we mean we never lost. I mean, the question is, you raised it before the magistrate, correct? This issue, this E2 issue, did you not?
We asked for them not to hold the hearing at all.
That's right. And then they made an R&R, right? Was received by the district court, report and recommendation?
Yes, sir.
Did you object in the
They
district
did
court?
not excuse the default. Again, we
I
won.
mean, no, did you object? You said you raised the issue in the magistrate, but you have to raise those objection in the district court. Otherwise, they're lost. We do it all the time in the Fourth Circuit. You people in prison, it works for them, but it doesn't work for the government. If they don't object to the R&R, when it gets to the district court, then they're waived, and nobody says a word about them.
Respectfully, Your Honor, I think that flows back into the division because you can receive evidence to excuse a default. You can't receive evidence for purposes of expanding the record for the underlying claim. until that division is
Before
accepted.
us, Counsel, I understand the division you're talking about, but before us, the state urged us to decide the underlying ineffective assistance claim based on the full record as developed by the magistrate judge. You told us, decide the case on this ground. And now you're telling us it's impermissible for us to look at the record you told us to look at the first time around. This seems to me, something more than a waiver. The state's taking inconsistent positions. The first time we were here, we were told, here's the record on which you should decide the underlying ineffective assistance claim, and now we're being told you can't look at that record to decide that claim. I mean, this is, I do feel a little bit sandbagged here.
Well, Your Honor, again, you have to look at the issue that's coming up. What was the appellant asking you to do?
You were asking us to decide the case in your favor based on what you apparently thought was a pretty favorable full hearing. You wanted us to be able to look at the attorney's explanation for why he did what he did. You thought you could win on that ground, so you asked us to decide the case on that ground. And when you didn't win, you have come back to tell us, that's wrong, you can't look at that. And that strikes me as very unusual.
When one argues in the alternative, it is the alternative, that is for sure. If you did not accept the position,
You didn't argue in the alternative. You didn't come before us and say, first of all, that hearing should have never happened. But if you disagree, if you think that hearing should have happened, we still win on the record. That's an argument in the alternative. That is not what you told us.
respectfully, that again blends the evidentiary hearing. That is exactly why we had so many discussions with the magistrate to make sure that it was separate. And now it's blending back again. We have never, ever waived intentionally the 2254E2 for purposes of the underlying claim. Now, you still look at the underlying claim for a substantive issue for the default analysis. That's always going to be part of it. Is it a bit confusing? Absolutely. And now it won't happen because the Supreme Court has made very clear you don't go through that step to get to the underlying claim. You look at the underlying claim first. All of the evidence that came in for the default analysis would not be allowed today under Shin. But that doesn't mean that it was for the underlying claim. Now, I want to go back a little bit to what Shin says, because it's interesting. It starts with some of the arguments for allowing evidentiary hearings, and it goes to the theory that this has to come in anyway, because Martinez, without showing that it's a substantial claim and that expansion of the record occurs, we'll never be able to use Martinez to actually excuse the default. The Supreme Court said maybe there's something that comes in for the excusal of the default, but we don't need to address that, keeping that separate and apart. You can't use it for the underlying claim, so it doesn't matter about the first part. This division is so important. This is the division that we argued repeatedly to the magistrate and in the district court proceedings, because we were trying to keep that separate. That is our motion to strike affidavits. We're not blending this back.
Counsel, I don't think there's any question. I don't think your colleague on the other side disputes that you raised this issue, and you raised it in precisely that divisible way before the magistrate judge, but I guess I'm not understanding how that sort of addresses the concern about waiver before this court.
Well, I believe this court in Hillman did make specific reference to Hernandez, so that is something that says, wait a minute, EDPA's different. Otherwise, there wouldn't be that reference. And the parenthetical that appellees are slightly different, and they may not have that requirement to raise as an appellant would a particular issue or argument. But let's look again, too, at Shin. What is the limitation in 2254E2? It's a limitation on the federal court's authority to act. It is restricted. It is mandatory. In Shin at 1736, the court recognizes the congressional limit and that the court cannot cannot decline to give it effect. That's the wording from the Supreme Court. Brown v. Davenport, very decided closely in time. A valid rule of decision, federal courts must follow it. Now, we do have cases from the Supreme Court talking about 2254D, part of the basic structure of federal habeas jurisdiction. This is how important that case or that provision is. They put it on a jurisdictional level. 2254E2 and 2254D are linked together. The Supreme Court did it in Cullen versus Penholster. These are limits on federal courts' authority to act. Now, it's not a defense. It's not something that should be waived or considered waived. It is a limitation on a federal court's authority. And let's look at it here. The Supreme Court has announced equitable rules, but when? When there was not text that would prevent it. For instance, statute of limitation. In Holland versus Florida, the Supreme Court said, in the absence of text, we will make this equitable decision. In Martinez v. Ryan, the same thing. It's equitable because it's not a claim. It did not offend the text of EDPA, the 2254I prohibition. Here, we don't have an absence of text. We have a direct limitation on the federal courts.
Why didn't you argue that in the Fourth Circuit?
Again, we're looking...
Why didn't you argue it in the Fourth Circuit?
Because we didn't lose on that point. There was
Because
nothing
you didn't
that we
lose.
had to...
You didn't think that was an issue when you were here? You're saying you had a knockout point on that issue, and you said there was no reason because you prevailed in the district court? Is that what you were trying to urge this court?
The information that was received went to the excuse of the default, and the default was not excused. We made our arguments based on that, and that's the record that came up before the court, and that was our position taken. We have never said that anyone should reach the underlying claim, and no one ever did before this court did. But if I may, I see I'm running kind of close to time. I wanted to introduce one other concept since we've been talking about whether, if there is a waiver, whether it should be subject to waiver. Let's consider this. If you accept waiver and you punish the state, what this court will be doing
We're punishing the
is
state
more.
because what?
Because
How are we punishing the state?
because we didn't raise an additional sustaining ground.
The Supreme Court has said a long time ago, death is different. You familiar with those cases?
Death is different.
Death is different.
EDPA's different.
No, but death is different.
And
you
EDPA
said-
limits death penalty cases. One of the basic theories of EDPA was to prevent delay in capital cases. This EDPA is a capital case.
Yeah, this is a case where
Precision.
because you allowed it to go through in terms of the evidence, a lot of evidence about a case where you put on one person for adaptability in prison, and the Aikens case, and those things, the overall context of this case, and you think that this case would be one that clearly is excused, no, not excused, that there's no jurisdiction at all when you've used it as a sword and a shield. Didn't you urge the district court didn't you urge the court to actually take some of the facts from those hearings to your favor?
Analysis, Your Honor.
Yes, but default about the strategy and the explanation of the lawyer. That's part of the IAC claim,
The
right?
substantial nature of the claim. There are two prongs under Martinez. But, Your Honor, I believe that you're raising a miscarriage of justice argument that all things should be set aside because this
No,
court
I'm
in a
not saying, I'm
divided
just saying
opinion.
that you talk about, what triggered my question when you said, should the state be punished? And punished by what? They can't execute him? You mean, what's the punishment?
The state would be punished by only responding in its brief of response and not going further.
Counsel, can I
That
ask-
is the
Counsel,
punishment.
Can I ask you a question that, I don't know.
Absolutely.
It might be similar to Judge Gregory's question. So because this objection was not raised before us, and because, and I mean, I was here, because we were urged to decide the underlying ineffective assistance claim based on the full record as developed below, we are now in a position, and I fully respect the state's contrary view and my dissenting colleagues' contrary view, but we are now in this position where, at the state's urging, we considered the whole record and we found that there had been a constitutional violation. And so you are asking us to let that unconstitutional death sentence stand because of a procedural default by the petitioner, because he didn't raise the constitutional violation at the right time in the proceedings. And to do that, we would have to excuse the fact that the state failed to raise its argument before us. And I have to say that just strikes me as very perverse. And I wonder if you can explain to me why that makes sense.
Absolutely. 2 points. The first is that the divided opinion from the panel was incorrect. It is not a constitutional error. There was a violation of Belamontes. There's a violation of Strickland. There was
Another reason other than we were wrong, because again, I fully respect my dissenting colleague's very thoughtful position, but here we are, we have this opinion, so what's your next answer?
Well, we do not give up the position that this court can't find a constitutional violation without correctly applying Strickland. That's very important. But above all, we talk about the waiver for the state because we didn't raise this additional sustaining ground or to present it in the way that, the manner that you took it, perhaps. But you're absolving the petitioner from all the limitations in 2254E2. Your Honor, I am running close. May I continue this one thought?
You may.
2254E2 has a miscarriage of justice exception, and the petitioner bears the burden of showing that there was a failure to develop that would excuse it, that he could not have developed these facts with due diligence. And the miscarriage of justice exception is limited to guilt, not sentencing. So to allow waiver would be to allow this defendant to escape all the limitations that Congress listed out in 2254E2, with this court for the first time being the only court to make the decision that there was any problem whatsoever with sentencing. And I remind the court that the magistrate didn't find that, the district court didn't find that Stokes had even gone to the state Supreme Court during district court proceedings, and our state court did not agree with that position. People differ on evidence that is offered in mitigation, whether it's truly mitigating in the context. People differ. But what we have is a structure that does not allow the result of waiver and escape from all the limitations in 2254E2. I thank you for your indulgence, Your Honor.
Thank you, Ms. Brown. Ms. Mazzina, you have a few minutes reserved.
Thank you, Your Honor. Just a few brief points in rebuttal. First, to the argument that E2 was not waived for purposes of the underlying claim. First of all, I think it absolutely was, and one place you can see that very clearly is page 71 of the appellee's brief in this court, where they say even if the court finds the default overcome based on Martinez, we should still win on the underlying claim. And even if they hadn't raised that, we were certainly seeking relief on the merits of the underlying claim. And so if they thought we weren't entitled to that relief, they had to raise that argument. If the state had, the implication of the state's current position is that everything that happened for a number of years, both in the district court and on appeal in this court, was a complete waste of time, because all of the debate about Martinez and excusing the default was irrelevant, because their view is you couldn't possibly win on the underlying claim because you can't even look at the mitigating evidence for purpose of the underlying claim. If that was their position, it made no sense to spend years litigating the Martinez issue, which is what they say they were doing. To this idea that you get, as appellee, you get to hold back your evidentiary objections, again, I think Judge Posner has a good answer to that, but really, if you just think about what that would mean, after every civil trial, the prevailing party on appeal could try to defend the verdict, and then if they lose, you'd get a rehearing petition where they say, actually, we'd like to raise some objections to the evidence you considered. That can't possibly be the rule. If you have an objection to the evidence the court is considering on the issue that's before the court on appeal, you have to raise that objection in conjunction with briefing that issue. This idea that E2 is a jurisdictional limitation, I think there's absolutely no support for that, and that would be a clear legal error. No court that we're aware of has ever held that. It would be inconsistent with the Supreme Court's repeated instruction not to read mandatory provisions as jurisdictional if they lack clear jurisdictional language. It would be inconsistent with how the Supreme Court has treated other similar threshold limitations under AEDPA. And it would be inconsistent with footnote 1 in Shin, where the discussion of forfeiture there would make no sense if the court thought it was talking about a jurisdictional provision. Finally, Your Honors, if the court thought that it had some residual discretion to consider excusing the waiver, and again, under Wood and Day, I don't think it does, but it would clearly, I think, be inappropriate to exercise that discretion here. I completely agree with Judge Harris. The state's position would apply a perverse double standard where Mr. Stokes would be executed without having been assisted by competent counsel because his ineffective PCR lawyers forfeited a claim, while the state's waiver by the state's presumably competent and effective counsel would be excused to allow that execution to go forward. That can't possibly be in the interest of justice. I think if you take seriously the concerns in Shin about the integrity of legal proceedings and about discouraging sandbagging, what's sauce for the goose has to be sauce for the gander. And I think if you apply those concerns fairly, you have to find the state waived this argument here. Thank you, Your Honors.
Thank you, Mr. Messina. Mr. Messina and Ms. Brown, we thank you so much for your arguments. We would love to come down and greet you in our normal Fourth Circuit tradition, but under circumstances, we can't do that. But know very much we appreciate your being here and wish you well and be safe. Thank you. We'll go to the next case. I'll try not to do misjustice to your name, but is it Boda?
Bodo rhymes with Frodo.
Okay. I would have done this justice. Mr. Bodo, please go, Bob.
Good morning. May it please the court. I am Andrew Bodo. I represent the appellant, Rebecca Snowboss. We bring to you a First Amendment retaliation case. A deputy sheriff of Spotsylvania County, Virginia, stooped to corrupting a fellow officer to retaliate against my client. She secretly promised to buy her colleague lunch if he would write a traffic ticket because of my client's prior Facebook post and citizen complaint. I want to emphasize at the outset how interrelated the questions presented are. We presented both evidentiary questions as well as the jury instructions. And as the court can see, the rulings as to the jury instructions will shape what evidence would be admissible. So it's important for the court, as it considers the evidentiary rulings, to evaluate them in light of the appropriate jury instructions. But turning first to the jury instructions.
Counsel, can I ask you sort
Yes.
of a threshold question that has been puzzling me about the underlying cause of action here for
Yes.
I think it's induced retaliation. So under Neves, there's no First Amendment cause of action for a retaliatory arrest that's based on probable cause. So why would there be a First Amendment cause of action for a retaliatory inducement of an arrest that's based on probable cause? Doesn't that just kind of blow an enormous hole into Neves?
No, for a couple reasons. First of all, the officer that we are suing had no probable cause. She, if you listen to the recording, she calls up and she says first, is your phone secure? Which means, is anyone overhearing this conversation? She then says, if you give this known boss person a ticket, I will buy you lunch.
But there was probable cause for the ticket, right? We all agree on that?
There was probable cause for
Okay.
the ticket, but
So
she did not have probable
Yeah,
cause.
but the point of Neves, right, is that we don't really care what's in people's minds subjectively. If there was objective probable cause for the ticket, can't be the basis of a First Amendment retaliation claim.
Another way to answer that question is the fact that the court below ruled that this was a valid claim, and that has not been challenged on appeal.
I agree, that's why this is just, and I'll ask your colleague about that too, that's why this is just sort of something that is puzzling me, like what to make of this.
Yes, but I think
Because
that...
I think it might help me understand, if I better understood the cause of action, I'm not just sort of spinning wheels, I think it might help me better understand the issue about the jury
Sure.
instruction.
I understand that. And perhaps the way to look at this is that it's not the ticket that creates the issue. It's not the ticket that creates the issue. It's the conduct that creates the issue. She ends up saying this in a recording, demonstrate her willingness to corrupt a fellow officer. And then my client sees that through the course of the criminal proceedings. She sees that this woman is willing to corrupt a fellow officer, to retaliate against First Amendment activity. And therefore, it's not the ticket that we're here about. It's the chill that arises knowing that an officer is willing to corrupt a fellow officer.
But wouldn't you have the same chill if you just knew that the officer who arrested you with probable cause was willing to come after you and keep arresting you with probable cause?
I don't think so, because this officer demonstrated through the order of that conversation, she demonstrated that she didn't care about the probable cause. She didn't know that there was probable cause when she made the offer of lunch. She then celebrated when she found out that there was a legitimate basis for the traffic stop, but she'd already made the offer of lunch before she even found out about the legitimate basis for the traffic stop.
Thank you.
So we raised objections specifically with regard to the de minimis inconvenience standard that was articulated first in Wicomico County case and most recently in the McClure v. Ports case. And though I count, this was a three sentences within the jury instructions. And I count about 12 issues in this one paragraph, 12 issues that I have concerns with. But there are 3 takeaways that should resolve the issue for the court. First, we only use the de minimis inconvenience standard to balance legitimate public interests against private interests. This is the lesson of Suarez and McClure. But the defendant's conduct...
Counsel, aren't you, I mean, I appreciate that you can draw that conclusion from those cases, but that rule, that principle doesn't necessarily hold true with our other cases on this issue, does it?
Yes, I think it does. I think it does if you look at the context of the case. So, for instance, you had the issue came up in Constantine, but was no bar to appropriate action in Constantine.
And that's where we really first developed this de minimis standard. It was in a footnote in the ACLU case from Maryland. It was really developed in Constantine. And the rule you're talking about isn't expressed in Constantine, is it?
They mention the standard.
Correct.
And then they don't, it's no barrier to that case moving forward. But then you have the case of Blankenship.
Right.
You have the case of Blankenship and the case of the Baltimore Sun case. Those cases did develop this concept. In the Baltimore Sun case, the court ruled that the government has a legitimate interest about deciding whether to answer a reporter's question.
But they didn't, I mean, fair enough, I guess, but that they didn't say the government interest dwarfs the private interest, as the footnote in McClure says. I mean, it looks to me like what you're doing in our cases is that there is a case-by-case analysis, and you look at the actors in every particular case, and you apply the de minimis standard. And because some cases seem to maybe involve what you just said, you're right, a legitimate government interest versus a less compelling private interest, you're drawing a principle that doesn't look to me like have articulated consistently in that cause of action.
Well, I think even before the McClure v. Ports case, this principle was articulated in Suarez. And Suarez did a very good job of developing the ideas of these First Amendment issues and how to analyze these retaliation cases. And in Suarez, they pointed that the de minimis normally arises in the employment-employer relationship cases. You can see, as it's developed, the courts have paid particular attention to the de minimis inconvenience standard when there's a special relationship between the plaintiff and the defendant, such as a employer-employee relationship, a jailer-jailee relationship, or a student-teacher relationship.
But we don't do it in the Blankenship case, and we don't do it in the Baltimore Sun case. And that's what I think those things, I think the issues you talk about are there in certain cases, so I'm not suggesting you're being, disingenuous in any way, but it just feels like what we've done is go on a case-by-case basis, look at what's going on in each situation given the respective positions, and then apply the de minimis standard. As Constantine says, a person of ordinary or reasonable firmness in their particular situation. So
and even if we go by that case-by-case evaluation, the critical issues that the court is looking at is discretion of the government official for what they do. Do they have proper discretion to do what they do? And is there a legitimate government interest?
Can I suggest another way of sort of synthesizing our case law? And I do agree, it seems a bit confusing. But what I understood was going on is that you always have to show, you have to start with these three elements, and one of them is the adverse effect, and that does require that we apply this non-de minimis standard. And then there are some cases where even when you have made that showing, there's almost like a defense that, all right, fine, this was retaliatory, but the government interest was so strong that we're going to not find it actionable. And that's what's going on in McClure. They're saying, this may have been enough to chill a reasonable person, but it doesn't matter because the government interest is so strong. But this isn't that kind of case. The government is not here, I think probably for good reason, saying, oh no, we had such a strong government interest here that this is not actionable. So this just seems to me clearly to be a case where we apply the regular three elements and we ask whether the harm is more than de minimis.
I can agree with that position, that because there's no legitimate government interest in this case, this shouldn't have been a jury question, which is ultimately what the court needs to...
Why is that? It seems to me it's a First Amendment case. If there's no effect on speech, if there's no chilling effect, because the conduct in question has such a de minimis effect, if there's no legitimate interest, I don't know, maybe you have a due process claim or something, but I don't see how there's a First Amendment claim if there's no effect on speech.
There was an effect on speech. For instance, Mrs. Snowboss...
I'm saying it's not de minimis.
It did affect speech, but the problem with this jury instruction is that it was written in a way that even if it affected speech, it could be still ruled de minimis because the court said, disregard hurt feelings and a bruised ego. You have to prove some specified harm, not a specific harm, but some specified harm.
I really want to be clear about your argument. So now you're not saying that the de minimis standard doesn't apply. You're saying that you do have to show that there was an actual adverse effect, objectively speaking, and subjective evidence can be relevant to that because it shows what is likely to have an objective chilling effect, and the district court kind of got that part wrong?
I have a layered approach. My first argument is that the de minimis inconvenience standard should be a question of law, or at least in this case, it is, since there's no legitimate government interest, the jury should not have been instructed as to the de minimis inconvenience
I
standard.
don't understand this. Say my mail carrier doesn't like my yard sign, and so because of my yard sign, disagrees with my speech, he usually does me the favor when he puts my mail in the box. He separates the catalogs from the regular mail, but this one day, he just gives them to me together. And he does it because he didn't like my speech. I don't even notice. You think I have a First Amendment claim?
The government has a legitimate interest.
No, there's no legitimate interest. He just didn't like my lawn sign.
But when...
That's why he did it. I bring my claim, I depose him. He's like, that's right. I figured that day you go through your catalogs yourself, lady.
And in the ACLU case, they did it because of the conduct. In the in the Ports case, they did it because of the conduct. It's not simply because of the conduct. The mailman has a discretion about how he puts it, how he organizes the mail when he puts it in your mailbox. It's that discretionary issue, that interest of he's moving through, he has to move through these mailboxes quickly. So,
Okay, but that's not why he did it. He did it because of my...
just as in Wicomico County and in Ports, they did it because of the speech, but they had a legitimate basis, legitimate interest and discretion about how they did it. But regardless, the appropriate standard to address whether or not that would chill your speech is the objective, ordinary firmness standard. Then it becomes a question of damages. In this case, damages were bifurcated from liability. And this is a jury instruction as to liability. Therefore, even if it was, even if it would be difficult to prove damages, we are only here as to the liability jury instructions as to this issue. And your issue about whether or not there would be adequate basis to prove damages then would be addressed through the damages part of the trial. I see that I'm out of time. I'll reserve the rest for my rebuttal.
Thank you. Kreiner.
Good morning, Your Honors. If it pleases the court, Justin Kreiner here on behalf of Ms. Curtis. Like the court, I had to gather a lot of this case from the record itself, as I was not present at the trial. However, in going through the record, what I want to make sure is clear to the court, I know is clear to the court at the outset, is that counsel was asking that we overturn not only a jury verdict in this case, in which there was no post-trial motions, no motion to direct the verdict. We made the only one. But counsel has also cited error on 403 balancing decisions by the trial court. So two of literally the most holy decisions that come up from the district court level are what counsel is asking that we disturb on this basis. Reviewing the instruction, as counsel has argued, de minimis is the law in the Fourth Circuit. Constantine is the law in the Fourth Circuit. We cited in our cases how Constantine got to the decision they did by pulling from the other circuits. And this jury instruction, as we pointed to in our brief, this jury instruction, the language contained therein, came from those cases in which Constantine cited in establishing the de minimis standard for this First Amendment retaliation.
Counsel, can I?
Yes, sir.
Can I ask you, something? I mean, one of the points your colleague has suggested is, the relevance of whether there's a legitimate government interest here, and it seems as if there's no suggestion, by you that there is one for the conduct that's challenged. Do we have a case where there is no legitimate government interest whatsoever, kind of like this one, where the de minimis standard has been applied?
I believe so, but not necessarily in this circuit. If the court, in our brief, we cite Carroll. Yeah, we cite Carroll out of the Eighth Circuit, which Constantine later cited, which involved, I would categorize it as literal harassment by a law enforcement officer in that case. If I remember correctly, they bumped into them at the card shop, said one of us is going to have to leave, shaking their fist, like a literal series of harassment in that case out of the Eighth Circuit. But they didn't do a government interest analysis in that case either. So I'll concede that. However, it's not applicable. The government interest analysis comes from McClure because of the status of who the parties were. They've sued Ms. Curtis as a private citizen here. The government is not a party to this action. And so what we have is Ms. Curtis as a private citizen, and as the court alluded to in its questioning, you look at on a fact basis. That's what Suarez told us to do, was to look at this on a fact basis for each individual case, decide who these people are as we do this analysis. Regarding the McClure case, I mean, the citation is to a footnote in that case. If it was intended to be the law that we relied upon, it would have made it into the body of the text. And so what we have here is a case where there doesn't need to be a legitimate government interest. That was a response, as Judge Harris had kind of alluded to. That's a response where, yes, there's retaliation, but there's an interest in the retaliation that overcomes the burden that it puts on the First Amendment. And so I don't think it's applicable. Regarding counsel's point on the jury instruction itself, the court is well aware of the standards regarding jury instructions under Bunn. You don't take one instruction by itself. You take all of the instructions as a whole for stating the law. Counsel's not only pointing to a single instruction, but specific, we'll call them amplifier words within that instruction. And as we know from previous rulings, the trial court has the utmost discretion in reading its instructions to the jury. And so there's really no reversible error here. We don't see an issue with the instruction because the instruction was pulled directly from Constantine. We took Constantine and we took the cases that Constantine cited, and that's the language that you find in the instruction there. So there's really no issue with the instruction. Regarding the, like I said, the court's suppression issues for the doctor in this case, they had an expert witness that they wanted to come in and testify to essentially the same facts as the plaintiff. They want a plaintiff's husband to come in and testify to the same facts as the plaintiff. In their brief, they assert that maybe Ms. Snowenbos would have been more believable if there was a witness there parroting what she said, but her testimony, as the trial court ruled, was the best testimony to give on the effect that this had on her, on what her actions were and what she did afterwards.
Constantine certainly sets forth that we look at this objectively.
Yes, sir.
And, but it also says that it looks at objectively whether the de minimis standard has been met. And that in and of itself might, support the trial court's decision here. But Constantine also says that the plaintiff's testimony is relevant to that. What's your response that our decision in Constantine that the plaintiff's testimony is relevant? I guess your point here is you got the plaintiff, you don't need the additional testimony?
That's correct. The plaintiff's testimony is absolutely relevant under Constantine for sure, and that's who testified in front of the jury. That's what was presented to the jury was the plaintiff's testimony, and it is relevant. So it's an objective standard, but so the standard is not subjectively the actual effect it had on the plaintiff. The standard is an objective one, the ordinary person of ordinary firmness standard, but the plaintiff's subjectivity is relevant, and the jury got to hear that.
What about can you talk a little bit about the poking the bear comment from 6 years earlier and what the grounds was for excluding that?
Your Honor, the grounds of that were that it was not relevant and not connected to the case. The poking the bear comment was made so far ahead, and there was essentially no explanation on what that would mean from 6 years previously, that it also was excluded on a 403 basis, is also not relevant to the case in any way. We took it as a vicarious liability that somehow Deputy Curtis would be liable for these statements that she never knew existed, made previously by another deputy 6 years ago, that we don't even have any context for what that deputy meant. There was no presentation of that deputy at the trial. And frankly, I don't know how it would apply anyway. I don't know. I don't think the trial court was wrong under any circumstance in excluding that, because how would it apply to the present case except for reaching 6 years in the past and trying to pull something out?
Well, wouldn't it be relevant to the fact that how broad, I mean, just allegedly, I suppose, how the disdain for her is, in terms of there's no temporal limit to their feelings about her in a negative way. 6 years ago, don't poke the bear. Now, 6 years later, you get stopped for a legitimate reason, articulable reason for the stop, but then the evidence is someone says, hey, listen, I'll buy you a meal if you make sure she gets this ticket. Wouldn't that gives context to, it's not dwindling at all. As a matter of fact, it to me would support the reason that you might be intimidated after the stop, because my goodness, 6 years later, someone is that concerned to, that's kind of outrageous, isn't it? I mean, I can imagine. You're scared enough when you get stopped by a police officer for a legitimate stop. But I can't imagine he or she calls it in and someone says, hey, who you got? Hey, lunch is on me if that person makes sure they get that ticket. And 6 years ago, you were told, don't poke that bear. Why would that not be relevant and give context to why it's not de minimis? And why I better watch my P's and Q's, walk on eggshells, maybe even stop driving, perhaps. I don't know how this case was tried, but, you know, I've tried cases, but that certainly would be in my argument somewhere in that court about what the impact is, and that's not de minimis. I guess, particularly, I don't know, demographics, for example, I don't know what it might be, but people have different views about what it means to be stopped by a police officer, and to say to another police officer who knows nothing about this stop other than know about you. You don't think that's outrageous, and that 6 year comment has context, and you keep that out? Respond to my long comment question.
Sure. Your Honor, plaintiff probably could have gotten that evidence in if plaintiff could have established a connection between those statements. The department is not the defendant in this case. The defendant in this case is Marcia Curtis.
Does that matter?
Yes, it does matter, because Ms. Curtis, the connection between Stillman's statements and Ms. Curtis. So Ms. Curtis is sued specifically for Ms. Curtis's conduct. She's not sued specifically for the conduct of the department. So other deputies' actions years prior are not relevant in any way to what Ms. Curtis did in this case. There's no connection established there between Stillman and Curtis in any way. There's not even evidence of them in a picture together. Anything like that could have been presented to the court. The court looked at it and said, this statement was made vaguely. It was made 6 years ago. It was made by a deputy who has no other connection to this case other than he had a conversation with plaintiff 6 years ago, and the court rightfully excluded it because it's not relevant. Your Honor, I believe, and I can't actually see how much time I have, but I believe I'm probably close.
Yeah.
I believe I've probably extended my time here, so I will rest on the remainder of the brief.
No, you don't. You haven't. Mine, I say,
Yeah, you have a right there in front
you
of
have
you.
9 minutes.
Oh, I've got plenty of time. Sorry, okay. Sorry.
Maybe I regret it, but I have to truthfully tell you,
You know what? I'm going to keep going then, because I'm on a roll at this point.
I figured you did. I couldn't allow you to believe that. No, your clock is well done. Go ahead.
Perfect. So, again, and what's important about this is that the case made it to a jury. We're not here. We made a motion for a directed verdict. The case made it to a jury. There was no motion for a directed verdict. There was no post-trial motions. And so at that point, it's got to be the standard is plain error under the Colombo case that we affirmed in this case, that if there's not a motion for a directed verdict, then if we're going to overturn a jury verdict, it's got to be plain error. And so we have an incredibly high standard to overturn that verdict. And as I alluded to before, in the Simpson case, when the court is going to make these exclusions, particularly 403 exclusions, they're left in the sound discretion of the trial court, as is their verbiage on their jury instructions. And so we're not only parsing an instruction here, we're parsing words within one paragraph of an instruction and saying that the law didn't make it to the jury. The jury heard their evidence. They just didn't agree with the plaintiff. And at that point, Your Honor, I think that's actually all that I really do have, so I'm going to reserve the rest.
I should let you sit down, but I just want to ask you a question. As you say, this case went to the jury, and you're not arguing at this point, right, that this case should not have gone to a jury. I gather that was argued below, and
It was, and actually, if a review of the transcript will show that Judge Novak seemed to lean towards granting that motion, but said, as a matter of caution, I'm going to allow this to go to the public and allow this to go to the jury. And quite honestly, I'm grateful that he did, because I'd be doing a different analysis before this court on that appeal if he had granted that motion. But no, we felt it should have been granted at that level, but the court denied our motion, sent it to the jury, and the jury came back with its.
Sorry, I meant back at the qualified immunity stage. When the
yes.
argument was there's no such cause of action, and if there is such a cause of action, it's brand new, and we were not on notice. But that's been dropped.
Yes, ma'am.
Okay.
I've never finished early before. I'm not sure what to do, judges. Thank you. I know it's frightening to sit down with the time, Ralph. Mr. Grider, thank you, Mr. Grider. Mr. Bordeaux.
Thank you, Your Honors. First of all, I wanted to address the standard of review. It's not a plein air standard of review because we're not challenging the jury's ruling as to the evidence. What we're challenging is the jury instructions that misled the jury. And the jury instructions are evaluated not under a plein air standard, but rather under the the two different layers of analysis where the jury instructions challenged, or do the jury instructions correctly state the law? If not, is there a reasonable probability the error affected the jury? And secondly, even if they correctly stated the law, did it adequately inform the jury of the controlling legal principles without misleading or confusing the jury? If not, did the instruction seriously prejudice the case of Ms. Nombos? So it's not a plein air standard because we challenged the jury instructions, and we quite plainly objected to and challenged them all at every stage of the process. The defense proposed jury instructions. We objected to them, this issue. The court proposed it. We objected to it. The court overruled our objections and insisted on presenting this jury instruction to the jury. Next, looking at the opposing counsel has represented that this jury instruction was pulled from the prior case language. That is not accurate. If you look at the specific words that were used, each of them is a corruption of previous cases. For instance, in the second sentence, there's a reference to specified harm. The closest that seems to be is the Abbott case, where it did not say specified harm. It said a specific incident or a specific, I have the language here, just a moment. It said a specific intended act of expression, not a specified harm. And there's a substantial difference between specified harm and specific intended act of expression. Who specifies the harm? If it's a specified harm, who specifies the harm? Where is that harm specified? What constitutes a harm, especially when the court goes on to say that hurt feelings and a bruised ego are not enough? And then looking at the hurt feelings and a bruised ego, that wasn't taken from case law from this circuit. That was taken from a Second Circuit case in which the court was trying to say, if you are a person who is not deterred in their speech, but suffered defamation by defamation per se, cannot bring a speech claim. A person who, where you don't even allege that a person of ordinary firmness would be deterred in your speech, you can't bring a First Amendment claim merely because it was defamatory per se, which is also consistent with this circuit case law. So the language of these instructions was a corruption of other circuits or of other case law within this circuit. It was not pulled from Constantine. It was not an accurate characterization of law. It was substantially misleading and confusing. And for that basis, that's one of the bases in which why we need to reverse it. But I think the court is going to be very interested in trying to parse out what this court means going forward with the de minimis inconvenience standard. I think that, properly speaking, The instruction that should go to the jury is the ordinary person, the similarly situated person of ordinary firmness. That is the standard by which we know whether this was so small that it should not be in the courts or not. That's the standard by which we use. When we add in there the language of a de minimis inconvenience, what that means is even if an ordinary person would be chilled, there are some things so small we're going to disregard the fact that an ordinary person would be chilled in their speech by this conduct. That's what it means to add on the de minimis inconvenience standard into the person of ordinary firmness standard.
But Constantine kind of did it in the reverse order of that, right? I mean, Constantine lays out the three elements. Then it says, but it can't, in describing element 2, says it can't be de minimis. And then it goes on to describe the person of ordinary firmness. So
In Constantine,
maybe you're right. Maybe that would be a better way to do it. Maybe we should go, kind of rewrite some of that. But they're both in there as explaining element 2, and B, you're kind of asking for a reversal, at least of the analysis that was done by a prior panel.
I don't think so. Number one is Constantine was decided not on a jury instruction issue, but on a 12b6 issue. Therefore, the legal question of de minimis would be an appropriate question to ask at that point. Once it gets to the jury, and the jury would only be instructed as to the de minimis or as to the person of ordinary firmness standard.
Counsel, can I say, I understand your argument, and if this jury instruction had in fact said, look, you have to prove a specified harm that would likely deter a person of ordinary firmness from exercising his First Amendment rights, but if it's de minimis, it doesn't matter. Even if it would deter someone, it doesn't count. Like that, I think, would be erroneous, but that's not at all what this instruction says. It says it has to be more than de minimis, and then it says that is, in other words, now I'm explaining, it has to be enough that it would deter a person of ordinary firmness from exercising his or her First Amendment rights. So I just don't, the possibility of confusion that you're talking about just doesn't sort of seem to exist with respect to this particular instruction.
You can see the issue also arises because of the way the court articulated it. When the court actually read this instruction, he throws a but at the beginning of this paragraph. So he reads the first 2 paragraphs, and then he says, but it has to be something more than a de minimis inconvenience. So that adds an element of confusion and ambiguity. I just want to, on the closing point, the court did suggest that Constantine allows for the plaintiff's testimony, as though it doesn't allow for other testimony. I think if you look at that, the question is not who gets to testify, but what is the subject matter of the testimony? The subject matter of the testimony is the actual harm to the plaintiff is some evidence of. And
if a district court judge says, look, the subject matter is relevant, but the plaintiff is the best person, and I'm not going to put on a lot of sort of superfluous, redundant, kind of one-step removed testimony as to the thing that the plaintiff can best testify to. I mean, you may disagree with that, but boy, that seems like core district court discretion to me.
I don't think it is the district court's discretion to decide which witness gets to testify as to the subject matter. For instance, if my client is a nervous client, if my client is a client who doesn't stutter well, or stutters or doesn't articulate well to the jury, we may recognize that the jury is not going to find her credible. It is self-serving testimony. It is self-interested testimony, and that itself makes it less credible to the jury. We may choose, if we have to put on one witness, we're going to put on her husband. We're going to put on her therapist. If we have to put on one witness, we should still be able to pick which witness we present on that subject matter. It may be the court's core discretion to decide that we get only one witness. But to say, she is the one witness that you are going to get put on, you're going to be able to put on, there are things she cannot talk about.
Did you guys say that to the district court? Like once the district court said, we're not doing the husband, did you say, never mind, we'll keep the plaintiff off and let's go with the husband?
The court didn't allow us to that. The court ruled both, and this, first with respect to the therapist, and then with respect to the husband, that they could not present because he ruled specifically that Ms. Snombos was the best avenue, that was his language, the best avenue for this information. and therefore he was not going to allow them to present in the case in
But
chief.
did I mean, I read those orders, but you think the district court, it did not occur to me that the district court had in front of it sort of a request to have someone instead of the plaintiff testify. I thought all the district court was being asked to do was allow all 3 witnesses, and he said, no, I'm not going to do that.
I see I'm over time.
Go ahead, please.
That's not actually the way it happened. First, what happened is the court decided to bifurcate the trial. And as sua sponte, we raised the issue, well, we have a therapist that's going to be testifying and may have some evidence as to liability. He insisted that we proffer that information. We proffered the information. He then ruled that that witness was not going to be allowed to come in.
On what basis?
He ruled 702 that it was centered around a 403 ruling, that her testimony was unduly cumulative, which we disagree. She had individual knowledge about.
Unduly cumulative to what evidence that you put on before?
That's the thing is, well,
How could it be cumulative?
I agree with that question. How can it be cumulative when he's deciding that we're going to use this witness instead of that witness?
But you had also, in your pretrial disclosures, talked about putting the plaintiff herself up, correct?
That was not until later. The ruling as to exclude Rapanchek happened right after the summary judgment motion, well before the pretrial briefing. Then what happened is we put on, during the witnesses and exhibit list, we identified Mr. Rapanchek as a potential witness. The opposing counsel said, we'll stipulate to one piece of his testimony. I said, that's not going to be enough because he has other information that is relevant to this question. And the court stepped in and interpreted their offer of a stipulation as a motion to exclude and then granted his own motion to say, I'm not going to allow in Mr. Snowboss because you're going to present that testimony through Mrs. Snowboss.
You know, in other words, the court was holding you to calling her?
We could only call her, he was only going to allow this testimony to come in through her. He chose our witness. We didn't get to choose our witness on this topic. For those reasons, we ask the court to reverse and remand the decision for further proceedings. Thank you.
Thank you. Thank you both. Appreciate your presence here today. And we can't come down and greet you, but know very well that we appreciate your being here and we wish you well. Be safe.
Thank you. Man, that is loud.
I'm good.
We'll call our last case for the morning.
Good morning, and may it please the court.
Yeah.
My name is Douglas Tirka. I represent the plaintiff, Jaime Sanchez, in this case. I'd like to start with what I think could be a useful review of some major issues the parties agree on. The parties agree that neither the IDEA nor the implementing regulations contain any statute of limitations applicable to a fees case. The parties also agree that this court has not addressed the issue, and as we know, other circuits are split. So in sum, the parties agree that nowhere is there published, well, codified or published in any other way, a statute of limitations explicitly addressing this case. The board, it appears, also does not challenge the fact that this court clearly ruled in CM that before applying a short limitations period to an IDEA case, there must be clear notice to the parents. The court below made some attempt to distinguish CM from the facts of this case, but as we reviewed in our brief, it appears the district court simply misread CM, and I do not read the board now to be supporting that part of the district court's ruling. On that notice issue, the board cites only one place where it contends that notice was provided, and that's in the procedural safeguards notice that it issues to parents in IDEA cases. The relevant provisions, as we know, are on pages 108 through 110 of the appendix, and specifically on page 108, the board claims there has been notice of a limitations period applicable to fees actions. In doing so, the board pulls out a handful of words out of a multi-paragraph section that refer to an action, or excuse me, the action brought, and ignores all of the other language that very clearly limits those actions to situations completely opposite to this one. And it starts at the very beginning of that section where it says, if either you or the school division disagrees with the hearing decision. Ms. Sanchez does not disagree with the hearing decision. She agrees with it and in fact must rely on it in order to bring her fees case. This whole section is for people who want to bring civil actions when they disagree with the decision, i.e. when they want to appeal that decision. In multiple other portions of this section, it uses similar language referring to people who are aggrieved by the decision, which is the language the IDEA typically uses for losing parties. And it uses additional language referring to actions brought regarding the issues before the administrative hearing officer. A fees action does not address issues addressed by the hearing officer. It addresses an entirely new issue, namely the fees, which is outside the hearing officer's jurisdiction. So this section of that procedure. Yes,
Counsel, I'm sorry. Just on this notice issue now, since you're talking about that, you know, it seems, at least in terms of the facts of the case, that CM involved a period of limitations where the particular statute had an express triggering point, which is the provision of notice. And the court there said that hadn't been satisfied. You know, so if you change the situation, whether it's this one or something else, is it your position that if we're having to borrow from an analogous state period of limitations, and the first time that's done, is your position by definition there wouldn't be notice?
If it is yes, and if it is a short period of limitations, that notice would be necessary.
So anytime we're borrowing a state statute, you know, we got to find short, I guess. That the first time that's done, there wouldn't be adequate notice, and the statute wouldn't apply. We have to have a published decision to make that happen?
Oh, no, Your Honor, absolutely not. The notice need not come from the court. So the board could have provided that notice in any form. Now, that notice of a short statute of limitations would have been more of a statement of position than an actual declaration of an established statute. But had they done so, either in the procedural safeguard notice, they could have done so at the bottom of the administrative decision. If we look at the bottom of the decision, it explicitly states a time limit for appeals and says nothing about fees actions. If they had provided in any form like that, even if they had sent an email to Mr. Ostrom, they could have done that and said, so you know, you only have 90 days to do this. Now, Mr. Ostrom may have thought, well, that's wrong. Yeah. But at least we wouldn't be talking about the notice issue. We would only be talking about the length of the limitations.
Can I ask you just a question about the timing in this case? So am I understanding this right, that the decision comes down and then 4 months later, sort of negotiations open up about fees, and then after the negotiations end, there's more than a year before there's a filing for fees? What accounts for all the time?
So there are two different reasons why that time passes. One is something that comes up quite a lot and something that we mentioned in our discussion of the public policy considerations. Work rarely ends at the moment an administrative decision is received. There's almost always some follow-up work, and this case is a good example. The hearing officer ordered the parties to meet again, ordered the board to revise the student's IEP. These are things that take some time to schedule and to perform. Sometimes it's a much longer period. Sometimes the order can say, meet, decide what evaluations are needed, perform those evaluations, meet again and revise the IEP. That process, in my experience, can easily take over a year. In this case, it took some months until that work was mostly complete on the case. So as we said in our public policy section, it would be really inefficient if a party had to file immediately.
What about the year
Yeah.
after the negotiations ended, more than a year?
This is-
Usually for equitable tolling, we're looking for kind of reasonable diligence and someone pursuing their rights. And this seems like, why did it take more than a year after the negotiations ended to file a fee motion? It's a 14-day time period in federal court. More than a year seems like a long time.
Well, first, I think this is a much more specific, narrower issue than a broad equitable tolling. I think this court has been very specific that in an IDEA context, a short statute of limitations goes against the IDEA policy. So it's not just a broad equity question. However, I understand that it is easy to say, what's the matter with Mr. Ostrom? Why did he wait so long to file this? The simple answer is he had more pressing issues. And I think that's to his credit. Mr. Ostrom did not come into the field of special education law so that he could litigate for his fees. He entered this field so that he could help children with special needs get services that they require. So the fact that he did not jump on this immediately, I think that is to his credit.
That may be, and I'm certainly not suggesting otherwise, but that's a kind of interesting position for us to try to maybe decide who's doing sufficiently legitimate stuff compared to other people. I'm trying to make sure how we apply. That seems hard for us to apply. A lot of people think what they're doing is kind of important, and maybe his is more important, but I'm a little perplexed by that.
I agree. That would be a very messy argument for me to come and make. I'm not making it. I'm just trying to answer the question. We're not arguing for broad equitable tolling. We're simply noting that this court has held that for the policies of the IDEA, a short limitations period cannot be applied unless there is clear notice. That was not about a broad equitable tolling idea. So, as we have reviewed here, that notice was not provided. The board's reference to these few words out of context, we can talk about that for a long time and we can parse this language, but I'm very happy to leave it to the court to read this section and answer for itself whether this is intended to apply to all civil actions or just to appeals. I think it's very, very clear that it applies just to appeals. And if we look at the very next section, which is titled Attorney's Fees, in those 2 pages, there's nothing at all about any time limitation. And in its brief, the board asserted that it need not put anything in this safeguards notice that is not explicitly in the IDEA. And we have no big problem with that. We don't need to make that argument. But I think it's interesting because the board seems to be simultaneously saying this safeguards notice mirrors the IDEA, and we agree, it does. And also saying the IDEA does not contain any limitations period for civil actions, which we agree, it does not. So if their procedural safeguards notice is just mirroring that language, as we can see that it does not provide notice of that limitations period. If the court does wish to address, does move on to the question of what limitations to apply going forward. As we've reviewed, we think that the most closely analogous sources of law are from the Virginia regulations regarding IDEA claims, and specifically IDEA initial complaints, and to the Virginia Code regarding personal actions. And those are most closely analogous to a fees case because in both cases, they address initial actions, cases that turn on new evidence, not an existing record, and cases that are decided by a simple preponderance of the evidence standard.
Can we look at analogous regulations? You obviously think so, and that might point us to the 2-year initial period that you're referring to, or it might point us to the 90-day period, whereas the statute, I think, only says 180. So I know your position about why you think one is better. I'm not really, but my question really relates to the threshold question of, we've talked about borrowing from state statutes, or is your position we can look at state regs as well?
Yes, Your Honor, because the precedent on this, well, I don't know of a precedent that addresses that specific question.
Right.
And that was one on my mind. But what they do say is that you look to the most closely analogous state law. And of course, we treat, state regulations as being, very instructive. If we don't want to go as far as to use that word, I think we are certainly operating within the principles that this circuit and other circuits have adopted in looking to what the state does in very similar situations. As it happens, both of those sources, the state regulations regarding initial IDEA actions and the state statute regarding personal actions have the same period, 2 years. We also know that the other circuits that have rejected the idea of a very short limitations period have looked to those catch-all, as has this court.
Can I just ask sort of, I guess it's like kind of a common sense question, because I think it's the Wilson case says we're supposed to look at the essence of the claim and then figure out what limitations period seems most appropriate. And how is a 2-year statute of limitations appropriate for a fee action, just as a very practical matter? It's not like you're coming to the dispute resolution process for the first time. You need to figure out your claim, get a lawyer. Like, all of that is done. You have a lawyer. You've won your claim. Why would it take 2 years to file a fees petition? Again, the rule in federal court is 14 days. 2 years just as a matter of common sense. Why is such a long limitations period appropriate here?
Well, if I may, first, Your Honor, and I'm happy to get to the question, but first, we're not talking about what's most appropriate or what makes the most sense, which is what the board has
The word
argued.
appropriate, I'm quoting from the Supreme Court, they do say, look for the most appropriate limitations period.
In this jurisdiction, and as in some others, we look at what is the most closely analogous and then have a secondary question of
What two things are supposed to be analogous?
the two types of actions. So in this case, the fees action.
It's not the limitations period. You think the two claims have to be analogous, not the two limitations periods? Because I think we're actually very unclear about that.
That's interesting. I mean, I haven't seen anyone argue, either the board or the judge below. I don't think anybody has suggested that the limitations period limitations periods would be analogous independent of the action types. So that's the way we've all addressed it, and I guess I'm having a little trouble understanding how that would be. So I think we argue to the actions. But I don't think I quite got to the court's question. I think you were asking, why would this be
Why does this
inappropriate?
make sense?
Well, if we were to look at it that way, as what makes sense as opposed to what's most closely analogous, we are into that public policy area. And in this case, I don't think either party can argue any prejudice from the limitations period going in one direction or the other, provided there's notice. Without the notice, we've certainly been prejudiced. But I don't think there's a credible argument that the board can make that it is somehow harmed by paying money later. I don't think there's a significant prejudice to a party having to file a fees claim earlier. However, I think there are significant, that may be too big a word, I think there are issues of judicial economy and of saving everybody time and money in bringing a longer period, using a longer period, because it allows for more settlement, but also, as I said, it allows for the development of the case, and it allows for the consolidation of multiple fees cases, which can easily happen and, again, allows for much more efficiency. If that time is not allowed for the development of the facts of the case, we have a situation which would have occurred in this case, where Ms. Sanchez could have filed immediately, worried about a short limitations period, filed immediately, and then asked the court to stay the case while her attorneys completed the work on the case, which, as I reviewed, could take over a year. Or I'm not sure what else happens. Maybe that case gets complete and she has to file a new one. It just makes for some messy things. Is that a disaster? No. As I said, I don't think the court's choice of which limitations period, if they reach that question, I do not think it will have enormous implications. I would not think to argue that. I don't think there's a reasonable argument in that direction. I do think if the court weakens CM and rules in this individual case that the notice was not required before applying this short limitations period, I think that is an injustice to this plaintiff, and I think it is a broader problem with the jurisdiction going forward. Thank you.
Thank you, Mr. Tirka. Cafferty.
May it please the court, John Cafferty for the school board. Members of the panel, I have a number of points that I want to cover, but let me, since counsel raised it and there were some questions about it, let me go right to the issue of the CM, this court's decision in the CM case and the issue of notice. First, CM is not a case about attorneys, standalone attorneys' fees actions at all. It's a case, and in fact, the CM case tells us some things that are very helpful. Counsel referred a number of times to the short limitations period. CM, as the court knows, applied a 60-day administrative limitations period pursuant to a North Carolina statute. And what the notice had to do with there was not notice of a limitations period, but notice when the clock starts. Notice when the clock starts. And the court says there a number of times a party is entitled to know when the limitations period begins. And in that case, the court says that a 60-day limitation period would have been appropriate, but for the fact that the school division did not provide the notice required by the North Carolina statute to let them know when the clock starts. That's a very different situation here. When it comes to standalone attorney's fees claims, we need to look at the provisions of IDEA that talk about, that tell us when you have to have notice of a limitations period. And that's important because that's in 20 U.S.C. 1415 D2, content of procedural safeguards. Obviously, this court had decided the RR case several years before the statute was amended in 2004, applying a limitations period, one of a number of cases going back to the Schimmel versus Spillane case, the Manning case, and then the RR case, cases where limitations periods, analogous limitations periods were applied. And to Your Honor's point, those were not the subject of any notice. Congress amended that section in 2004 to provide subsection K, civil actions including the time period within which to file such actions, and then L, attorney's fees. So it's important. So our position with respect to just the statutory construction point is there's either of two possibilities. Either this standalone attorney's fees action is a civil action, including the time period within which to file such actions, and it's controlled by the general either 90-day or Virginia 180-day limitations period, something that counsel concedes, and it's clear from the record, is in the procedural safeguards notice, or it comes under subsection L, attorney's fees. And importantly, as we pointed out in our brief, by the time this was amended in 2004, there were at least 15 years worth of standalone attorney's fees actions. If Congress wanted to add the same qualifier, including the time period within which to file such actions, they certainly knew how to do that. They didn't do that, and the legislative decision apparently was to allow analogous limitations periods to be developed through the courts, ones that could vary from one situation to the next. If you look at the procedural safeguards notice, the Virginia approved version of the procedural safeguards notice, what it says is, and this is on counsel's right, Joint Appendix 108, 109, civil actions including the time period within which to file those actions. And then you go, the party can bring the action has 90 calendar days or 180 days to file in state court.
So I just want to make sure I understand where you're going. I think I understand your position that what you just referred to in the procedural safeguards would be adequate notice.
Yes.
It sounds like that's what you're saying.
Yes.
Before you get there, are you pointed out that CM wasn't an attorney's fees case,
Right.
and I get that. But is it from that, do you decide, is it your position there is no notice requirement for this, the period by which a claim for attorney's fees must be made, or that there is, and this Virginia procedural thing satisfies it?
What I would say, Your Honor, is that the text of IDEA does not require the provisions that I just gave you. Right. That the text of IDEA does not, 20 U.S.C. 1415 D2L unlike the preceding section K, does not actually require notice of a separate notice of the limitations period for a standalone attorney's fees claim. But even,
So you're saying, is your primary argument then is this whole notice thing is just bunk? We don't have that anywhere.
I wouldn't say it's a primary argument. I would say it's either of, we make both of 2 points. One is that, and this court's decision in the RR case essentially says that. What it says is you can't require school systems as a matter of IDEA procedural safeguards to put more in their procedural safeguards than IDEA itself required. In other words, even if the procedural safeguards were essentially a copy of IDEA and a copy of the Virginia Code, you wouldn't know anything more than in this procedural safeguards notice. But furthermore, Your Honor, even if, because part of the reason why we're having this discussion, really the whole reason why we're having this discussion, is because IDEA doesn't have a separately delineated attorney fee, a standalone attorney fee limitations period. And so we would further say that if you have to provide notice of anything, it's notice of what is included within IDEA as a limitations period for civil actions generally. After all, attorney fee claims are a version of a form of civil action. And what IDEA says, what the procedural safeguards notice says, is 90 days for federal, 180 days for state. And we think that's consistent with this court's decision in the, among others, the RR case.
Counsel, can you, I'm coming to some of the statutory framework kind of new. And you say there's no specific provision for a limitations period for these standalone fee actions, but isn't the kind of bigger reason this is all so confusing is that there's actually no provision for the standalone fee actions at all?
Yes.
Right, that makes this whole thing very confusing.
And that's an
Great.
argument, I'm sorry, I don't mean to get.
No, it's all right, I'm excited too.
And you'll see that in our brief. That's an argument, frankly, that I lost about 25 years ago.
Yeah, and I'm not suggesting, right, it's been implied, everybody agrees, it's not at issue, but it does make this very confusing because there's nothing about it because it doesn't, it's not in the statute.
It absolutely does, and interestingly, if you look at 20 U.S.C. 1415I, the right to bring a civil action, and then that's what gets us to, that's the part that was amended to give us the 90 days, or you can refer to the state 180 days. That's not where standalone attorney's fee, that's not what authorizes standalone attorney's fees claims. Those are authorized by subsection 3, jurisdiction of the district courts. So the limitations period resides in the preceding section. I will point out that whether you're talking about I-3, which is authorized standalone attorney's fees claims, or I-2, which authorizes judicial actions to, we say appeal colloquially, they're not really actions challenging a hearing officer decision. That's in a completely different subsection of that statute than the 2-year limitations period that applies to initiating due process hearings in the first place. And I think some of the practical reasons that Your Honor talked about is, but by the time you get to attorney's fees claim, you've been through a whole hearing, you've been through witnesses, you've been through everything. The notion that you would need 2 years or anything like that to, when there are many shorter limitations periods, I think for practical reasons doesn't make any sense.
So, counsel, can I just, I don't mean to interrupt.
You're the people who need to understand.
So, I'm just thinking, this isn't really in the record, and I'm not 100% sure how it fits in, if at all, to how we decide this. But, in my old normal litigation world, if there was a claim for attorney's fees related to a case, it's somewhat of a follow-up of what you've been talking about. It's almost always in the prayer for relief with the substantive claim. So if the statute allows for attorney's fees or a contract allows for attorney's fees, I almost always say, I win on the merits and I get attorney's fees. Practically speaking, is that what happens in this IDEA world, in the state claims, that when people seek hearings and speak special education services, do they also seek attorney's fees? And I don't think the record had it here. Did this one?
I mean, it's been a while since I looked back at the request for hearing, but I've been doing these for 36 years. And I started the same year the statute was amended to allow for fee shifting, 1986. So I've never seen one that did not, honestly. That would be the typical process. And I think if you look in Joint Appendix 50 to 51, Mr. Ostrom's affidavit, he doesn't suggest otherwise. I want to make sure, because I know my time is limited, to mention a couple other things that I think that are important that are related to this. One of them is counsel says, well, the school system isn't prejudiced. The school system is prejudiced in a significant way, and that is this. Even from the four corners, you don't have the administrative record below of the 2 days of hearing and so forth, but even from the hearing officer's opinion, which is in the joint appendix and in the papers, you can see that the hearing officer ruled that the student was receiving educational benefit. Student was benefiting from being with other students. Denied the claim for a compensatory relief, and essentially said there's some mathematical problems with the IEP, an IEP that had been written by Mr. Ostrom, by the way, when he was the child's teacher, sort of a remarkable fact. But this is not given what the hearing officer's decision was. This isn't a hearing officer opinion that the school system would have had any reason to challenge in court. Now, we know they have 90 days to do that, or 180 days to do that in state court. Under the rule that counsel is contending for, a plaintiff could, and that to some extent happened here, frankly, wait out, make it too late for the school system to challenge the hearing officer opinion, and then come back and say, well, you only had 90 days to take this to federal court, but now I have 2 years to seek attorney's fees. And honestly, there's just as having a system where those two time periods are congruent, we think makes a practical sense. Although honestly, if you look at the rule of accrual that Judge Ellis applied, and not just Judge Ellis, the district court at Mayo did it, and Richardson and a number of others, it isn't 180 days, it's almost a year, 360 days, because his rule of accrual, just with all due respect, I disagree with that. I think that accrual clock starts at the time the hearing officer's opinion is rendered, but even under his rule of accrual, you get 180 days plus 180 days, and 360 days. If you can't put together a fee claim when in this court or in the district court, it would have to be done within 14 days. And let me say this too, when you look at, we deal with it in the briefs, assessing claims for attorney's fees is not, as Judge Ellis put it, looking at timesheets and taking a glance at the administrative opinion. Far from it, and this case is a good illustration of why. You have the issue of, were they a prevailing party at all? I know that the clerical report that the hearing officer filed with the opinion of the decision says that. The decision itself doesn't. And honestly, our position is that his case status summary, I think it's called, is just in error, because he denies the relief that's asked for, and the only thing that he ordered the school system to do is something the school system had been trying to do anyway. So even if you have the issue of, were they really the prevailing party? Even if they were, to what was their degree of success? And importantly, we gave the provision of IDEA. Were there things that the parents, or frankly their counsel, did to try to obstruct or interfere or delay or protract the proceedings. That's an important issue under IDEA. All those things require the court to get its hands dirty with the administrative record, so that it's not just a perfunctory look at that. I want to make sure that as I say, you can read the cases. We think that Judge, no way I'm going to do a better job of case analysis than Judge Ellis, but I do think he has the Richardson case and those other cases have really the better end of the argument. These other cases from other circuit courts apply very short limitations periods, 30 or 42 days. That was an issue that was decided in the Schimmel case, although this court's decision in CM says 60 days can be long enough. Those honestly, unless the panel's got other questions, those I hate to leave I hate to leave time on the clock, but I really think I've covered the points that I wanted to make, and otherwise, thank you for your attention.
Thank you. Tirka?
Thank you. I didn't hear the board press its argument that this section of its safeguards notice actually provides notice of a limitations period for fees actions, and I'm glad, because I think it's very clear that it doesn't. I did hear this suggestion that CM would not apply to this case because CM turned completely on the state statute in that case. In CM, the court did not speak narrowly. To the contrary, it said a generally applicable, very short limitations period for IDEA actions in federal court without any requirement that school authorities provide clear notice of the limitations period is inconsistent with federal policies embodied in the IDEA. It does not say it violates state law. It does not say any of that. It does mention the existence of a law, which it found relevant, but that was not the entire basis of its decision. Regardless, in our situation, the IDEA, the federal regulations implementing it, and the Virginia regulations implemented, all do require notice, and I'll quote, of the availability of civil actions, including the time period in which to file such actions. The IDEA does also require that notice along with state and federal regulation. Regarding the question of whether and why the due process complaint did or did not address attorney's fees, as you noticed, Your Honor, it's not in the record. Frankly, I don't recall in this case. I do, however, know that that's not within the jurisdiction of hearing officers. They address issues of FAPE, not this question of attorney's fees, which would occur after the fact. Hearing officers also don't do any kind of bifurcated proceeding where first they decide the substance, and then if there's prevailing party status, they would determine the fees in the way that a district court would. On page 26 of the record, we have, well, 25 to 26, we have the relevant sections regarding what the hearing officer decides, why the hearing officer decides it. And then on page 26, starting with, how far in are we? I guess it's I3, 1415 I3. It talks about the jurisdiction to determine attorney's fees, which lies with the district court, not with the hearing officer. It is true that the IDEA doesn't talk exactly about what kind of order a hearing officer can issue, and they certainly have some discretion, but I've never seen any suggestion anywhere that they could award attorney's fees. The board's argument regarding prejudice, I'm sorry, it makes no sense to me. So what I heard was that if there's an appeal deadline of 90 days and a fees deadline, I mean, what they're proposing, and a longer fees deadline, that they would lose their chance to appeal by the time they got notice of the motion for fees, which I understand that concern. They'd say, well, if it's a big claim for fees, maybe we will appeal this. Maybe it'll be worth our while. I understand what they're saying there. However, what they're asking for is 90 days. So if the plaintiff files their fee claim on the 90th day, obviously the board has already lost its own opportunity to appeal by the time it gets that notice. So either way, that prejudice that they are worried about, that exists. Finally, the issue of the prevailing party, I know that the board has a lot to say about that, and of course, they have every right to make all of those arguments. Those are the arguments that are made before the district court on the substance of this case. Every argument about whether the district court, or whether the hearing officer was correct when the hearing officer explicitly held that Ms. Sanchez was the prevailing party, whether the hours spent were reasonable, whether the hourly rate is reasonable, all of those things can be argued and should be argued if the board has arguments before the district court when this court orders that the case can go forward because it is not barred by a statute of limitations. I sense no further questions, so I guess I'll be the third in a row to walk away with time. Thank you very much.
Thank you, counsel. Appreciate your arguments. Know very much that we'd like to greet you, but we cannot, but know we appreciate your presence and assistance in this case.